Can a single word change the outcome of a 20-year legal battle? In a landmark ruling delivered just days ago, the Supreme Court of India answered that question. Done, and the word in question was may. One word, two competing high courts, one definitive answer from the highest court in the land. The case is Canara Bank versus Prem Lata Upal. Decided on May 12, 2026, the bench comprised Justice S.V.N. Bhatti and Justice Vijay Bishnoi. At its core, this is a disciplinary proceedings case, but the Supreme Court has used it to settle a crucial question of statutory interpretation. This ruling will affect every public sector bank, every regulated institution, and every disciplinary authority in India. Prem Lata Upal was a senior manager at Canara Bank's Diplomatic Enclave branch in New Delhi. She was a member of the Credit Sanction Committee. She was one of 3 officers who approved loans to 2 trading companies. Those loans turned out to be sanctioned without basic due diligence. No verification of the borrower's existence. No independent check on collateral. Loan documents signed by impersonators. In 2005, she was charge-sheeted. In 2006, she was demoted, reduced from SMG Scale 4 to MMG Scale 3. 6 other officers involved in the same transactions got away with minor penalties. Just denial of increments. She fought back through the courts. 2 questions came before the Supreme Court. First, did the Karnataka High Court's division bench exceed its jurisdiction in reviewing the disciplinary findings? Second, and this is the big one, does Regulation 10, which uses the word may to allow common proceedings, actually mean shall? The High Court of Karnataka had said mandatory. The High Court of Andhra Pradesh had said directory. The conflict needed to be resolved. On the natural justice point, the Supreme Court confirmed the division bench's finding. The inquiry officer relied on statements that weren't cross-examined. The respondent never got a chance to rebut that material. That is a textbook violation of natural justice, and the punishment order fell on that ground. But on Regulation 10, she adjudged on the may versus shall question. The Supreme Court held that may is not understood as must, so long as the English language retains its meaning. Regulation 10 is a facilitative provision. It gives the bank power to order joint proceedings. It does not create a right for the employee to demand them. What does this mean on the ground? For banks and disciplinary authorities, you retain full discretion to tailor your proceedings accordingly. For employees, the why not them too argument is now closed. You cannot use Regulation 10 as a shield against individual accountability. This judgment is a must-read for HR departments and compliance officers. For the full analysis, read PV Legal's daily newsletter. This is your host signing off for PV Legal's daily newsletter. Stay informed, stay vigilant.